Well, let's do like a first administration before the meeting.
Here comes John.
I like John's.
That's
Very good. Public purposes, interested owner allowed, I think that's illegal.
So I don't believe it is. We've had discussions about this with town council and, they're not speaking. It would be like somebody in the back row at a meeting, not identifying themselves. So, and we're not accepting public comment, but if they were to speak, they would have to identify themselves.
But Steve, if they say uninterested owner, we might have to question.
Yeah, that's
What are you doing
actually
here?
talking at the.
I have more questions about the interested people.
They change the name to make it not being recognized.
Oh, yeah, that's a good point.
Oh, that's interesting.
It's tricky.
That's a tough one.
Okay.
Anyway, so good evening all. Welcome to the June 6th, 2024 Select Board led short-term rental subcommittee. I'll call to order at 6:03 p.m. Tonight, I think we are going to discuss, well, let me just jump off from last meeting. I thought it was a good meeting. I thought we off the list that Mr. Cohen created, which kind of centered the discussion on lots of different zoning topics. We got to discuss all 13 of them, obviously with a lot still in the parking lot still to discuss and some legal questions that need to be plowed through. But overall, I thought it was a really good discussion. I appreciate everyone's participation in that. Amended today was the packet with a couple memos and a chart that Mr. Sanders created with all three groups and potential compromise, et cetera, but what everyone's general position was. I'm sure he did it from the video, which is wonderful. Thank you for doing that, Grant. That was really nice.
And the chart that was in the packet that was uploaded this afternoon has actually since been revised to reflect some comments of Charities. So we have it here and I can display it and I'll switch it out tomorrow.
Thank you, Erica. And so Erica, would you please share the STR zoning topics sheet? So on the list that we were plowing through at our last meeting, there was, I think, a feeling of some general consensus in the 2 to 8 range and then on 10 to 13. But it was really 1 and 9 that were the legal sticking points and a lot in the parking lot still to discuss. This includes the Y versus A and 30 days and et cetera, et cetera. I think that is the biggest piece of them all and a good jumping off point tonight. John Giorgio from Town Council's office is with us tonight, as is Dave Iverson, Chair of the Planning Board, and Leslie Snell, Planning Director. It is with us, and I think we'll kind of jump off the discussion. John, do you want to start some comments on kind of what you and Devin spoke about and the 3 articles as far as numbers 1, starting with number 1 on the zoning topics chart?
Good evening, everyone. So, yes, so I think there were a number of legal questions that came up, or at least a few legal questions that came up at the last meeting. I think one of them had to do with the effective date of the bylaw. If I understood correctly, the group members wanted us to explain what the effective date of a zoning bylaw is. Is that correct?
That was one of them. Yes, John.
Can I start there then?
Yes, please.
So unlike a general bylaw, which only takes effect after approval by the Attorney General and publication of the bylaw by the town clerk, a zoning bylaw actually takes effect on the date that it's adopted by town meeting. It is still subject to a review by the Attorney General, but assuming the Attorney General approves the bylaw, the effective date relates back to the date that it was enacted at town meeting. If the Attorney General disapproves the bylaw, then of course it doesn't take effect at all, notwithstanding that it's in effect on a temporary basis until that review is completed. The bylaw can provide for a later effective date, a zoning bylaw. And that's something that the group could consider if you wanted all or a portion of the substantive provisions to take effect at a later date. Everybody got that?
Yes, thank you.
What were the other question had to do, I believe, with the issue of residency requirements and how that might be impacted by the Commerce Clause issues that have been discussed. I believe that's still an outstanding question. In discussing this with Devin, I think it's our view that any provision that the group comes up with should really focus on occupancy of the dwelling unit as opposed to residing there, or it being the primary residence is a problem. And so our view would be that you may want to consider changing the terminology and essentially say that, and let's just assume for a moment we're talking about the minimum 30-day stay. Rather than saying the owner must reside for 30 days, it would be better, in our view, if you stated the owner or operator must occupy the dwelling unit or another dwelling unit on the same lot for a minimum of 30 days a year. That we think that makes the bylaw, at least as of now, most defensible when it comes to any potential Commerce Clause violations or issues with the Commerce Clause. Because anybody, whether you are a resident of Nantucket on a seasonal or a year-round basis, you would all be treated the same. You must occupy the unit for a minimum of 30 days. And so that would necessitate adding the definition of owner and operator to the zoning bylaw, which is easily done. And that would be something we could take those definitions directly from Chapter 123, the amendments that were made at the annual town meeting added owner and operator. And those definitions were based on the definitions that are contained in Chapter 64G of the general laws. So I'm not sure if there were any other legal issues specifically that you wanted to address, but I'm happy to do so if you ask me.
Yeah, can you clarify the difference between an owner and an operator?
Yes, so yes, just give me half a moment here. I will go to where is it? Here we go. So in the Chapter 123, and I'm sorry, wasn't quite ready here.
No problem.
Operator is in there.
Basically, the operator is defined as any person or other legal entity operating a short-term rental, including but not limited to the owner or proprietor of such premises, the lessee, sublessee, mortgagee in possession, licensee, or any other person otherwise operating such short-term rental. That would be the definition, which is currently, as I said, in chapter 123, that we would insert in this zoning bylaw amendment.
Sure.
John, I wanted to ask you a question because when we reviewed this with you, seems like months ago, but it was only a few weeks ago. You said our article was acceptable because we do not make any reference to owners or anything else, and we use a lot is used for residential use. At least 32 days for.
I'm sorry, could you speak up, Charity? I apologize.
No, I just wanted to be sure that what you advised us was that our representation of referring to lots and residential use as opposed to owners and operators of primary residences and so forth remains acceptable.
Yes.
Thank you.
Jim, John, I just, for the benefit of our friends who are lawyers who are watching, I just wanted to read out loud in a second what Devin sent to us today from your office. And the two cases that cited this as being all right were Rosenblatt versus the city of Santa Monica and short-term rental of San Diego versus the city of San Diego. And it seemed like there was a legal precedent. So I want to thank your office for.
Yes.
Those.
Yeah. I would, Jim, caution everybody, though, that this is an evolving area of the law. And a lot can happen between now and when this bylaw, should it be adopted, goes into effect in terms of other legal precedent. But we'll be monitoring that. And if we need to make adjustments along the way, we will certainly advise you accordingly.
Thank you.
Any other questions on this for town council from the group? Okay, I think the effective date was clear. The residency based on their advice is clear. So
I have a question for Mr. Giorgio.
Matt.
So, Mr. Giorgio, does this, by requiring some sort of owner occupancy, does this change your opinion then? As far as the Y or the A in the use chart, because this kind of gives, this is going to be accessory use.
I don't think this changes my opinion about the Y or the A in the use chart. No. The issue of whether you say primary residence or reside or year-round residency has to do really with a minimum use of the property by the owner or the operator. So my understanding is that there is an interest in establishing a minimum number of days in a calendar year that one must occupy the dwelling unit in order to be able to short-term rent at all. And that is really, it's with respect to that particular regulation that we're making this recommendation about using the term occupy and adding owner and operator to the definition of section.
Steven?
Tom, through you to John. Does that mean that a lease to somebody who's not the owner or the operator would not qualify?
If a property is leased to an individual, and that individual chooses to short-term rent the property?
No, that's not the scenario. I mean, we lease the property to a teacher, is the example we hear a lot.
Yeah.
And they are the occupant, but they're not the owner or the operator. Does that
Well,
satisfy?
Stephen, under the definition of operator that I read out to you,
Yeah.
it includes any lessee. It includes the owner, it includes the a lessee, it includes,
But it's the lessee for the purpose of operating such bed and breakfast establishment, hotel, lodging house, or short-term rental. It's not just.
Right.
a-
that's correct.
Let me see if I could try to clarify that and get you, John, to see if you agree or not. I think that, Stephen's point that to meet the Commerce Clause, you're saying that a residency requirement, at minimum would have to be owner and the owner and would have to be at least owner and operator, which is fine. And I think Stephen's point is that actually, if you did a 30-day lease to someone who is not involved in the short-term rentals at all, that wouldn't be an owner or an operator. So that if we have a residency requirement, a non-STR occupation requirement, we, I think, would want to include those three categories as opposed to owner operator. If we're going for this idea of renting it to a winter tenant who doesn't STR. Right, is that?
Yeah, that's right. Yeah, owner and
Yeah.
operator doesn't include.
You would want to include lessee in that definition then.
Yeah,
Yeah,
we're gonna do that or not.
I think that's fine.
I think that we're clear on what's legal now. That's what's legal today.
Got it. Okay, so going back to, I think, number one, which is obviously the kind of the cornerstone. Anybody have any new thoughts or want to open up the discussion on any new thinking to where any of the groups are at on that?
Yeah, I'm feeling about this.
So,
Stephen?
yeah, I have a comment on that, which is that I think Charity's group, where they're putting the Nantucket Neighborhood's first proposal, misunderstands the idea of what's ancillary under the zoning use chart and what they want it to be. And what I mean by that is that that term is currently undefined, and it's going to be defined, probably on June 24th by the zoning board when they make a ruling in the Ward versus Gray case. That'll be an official decision on what that means or doesn't mean. And I think that they are stuck on this A based on the assumption that it means X, and I think we might actually see that it means Y, which might not make them happy. And I again suggest that instead of focusing on ancillary or not, we focus on what's allowed or not allowed. Because I actually think you're not going to be happy with how the zoning board rules, and that putting an egg in there would be far more expansive than you actually intended to be.
Well, we use accessory, not ancillary.
Well, accessory, yeah, but what I'm saying is you're assuming that accessory means what you think it means. And I think that there's a decent chance that the zoning board is going to rule that it means something much different. And then you don't have any of the protections that you thought you had. But we could put them in these regulations, regardless of whether there's an A or a Y. I think you're getting caught up in the wrong place.
Well, you're entitled to your thoughts.
Yep, those are my thoughts.
May I, Todd, may I make a comment about that?
Please.
So, this is really a question for Charity and a recommendation by me after listening to Devin about the discussion the other night. I believe there was a discussion about adding short-term rental, that term, to the use chart and designating a no in all districts.
Yes.
And then adding the second definition, which would be something like vacation rental, and putting a Y in all districts except the CI, and of course with the note that you must comply with the regulations in section 38. I thought that was an excellent suggestion because it would shore up, I think, what Charity's concern has been that putting a Y in there would open the door for all short-term rentals. And I think if you proceed it with a STR with a no, with an N, I think that goes a long way, hopefully, in satisfying your concerns, Charity, but I don't know if it does. I think it does, but that might be a way to satisfy your concerns. And I don't obviously mean to speak for you, but I thought that was a rather elegant way to try to bridge this gap.
Well, I think the discussion, Stephen made a recommendation for another term, which is primary short-term rental. And that would have gotten a no. And that would have been, I mean, I think we're running far afield here, because how do we define a vacation rental?
That's what we're doing here.
In section 138. That's what.
So the definition of vacation rental would be a short-term rental that complies with chapter 139 -38, which would be all the substantive regulations. So all we would do, rather than calling it a accessory short-term rental, we would call it a vacation rental. There would be a Y, but you'd have to comply with all of the substantive regulations. And Charity, you already say in your proposal towards the end that all other short-term rentals are prohibited. Well, let's put that right in the use chart up front. And put a no.
Stephen?
I just want to make the point for everybody who might not be aware, section 38 is of the zoning code. So when we're talking about the substantive, when you're talking about the substantive regulations, you're saying in zoning, not in general bylaw.
Well, except, yeah, that's true, except that section 38 also says you must be in full compliance with chapter 123 of the general bylaws in order to take advantage of that Y designation.
Correct.
So, yeah.
But the important pieces that people are concerned about changing with a simple majority, those will be in the zoning bylaw. You cannot
Right.
accept
Right.
that.
If it's in section 38, it will require a 2/3 vote at a future town meeting to change those.
Dave Iverson?
Thank you, Mr. Chair, and John, please feel free to correct me if I'm wrong here, but I think Stephen's idea is genius. Just to settle people down and help them understand that regular short-term rentals are not an allowed use, and that all of these articles have a definition that they're putting into zoning, defining short-term rentals. In Charities, for instance, she's adding a definition that someone has to live in there for 31 days, so on and so forth. In I believe in Stevens and even more so in grants, there is a definition that will be in 139 that defines short-term vacation rentals with a lot of regulations. So a yes is not a scary thing. If you go back and you read how short-term rental is defined in grants, I don't have it in front of me, but it comes with a lot of conditions. So a yes with that definition backing it up in 139 is not scary anymore. It's not letting people have short-term rentals. It's saying you can only, if it's new, you can only have 4, you can only have a certain amount of changeovers. There's a lot of regulations built into 139 that would not allow a regular short-term rental. Is that an accurate description, John?
Yes.
Yes.
So the protections are built into the definition in 139. And so even if it says, in Grant's case, if it says yes, that short-term rental has to fall within the definition in the zoning bylaw. So it doesn't it doesn't mean you can just have a short-term rental. It means it's only an allowed short-term rental if it follows every item in that definition. So I think part of this is having people understand that all of this pieces of these definitions that are in 139 are going to take a 2/3 vote to change. And so if there's a yes in the column, it doesn't mean it's rampant STRs. It means you're allowed to have an STR if, you know, A, B, C, D, and E are met. And that's in the zoning. That's not a general bylaw. That is in the zoning where it takes 2/3 to change. And it's a durable move. I mean, I'm not going to go there, but I just think that the protections are built into zoning and they're hard to change, and that's what people want. So I like Stephen's idea to add a little bit of maybe, I don't know, comfort to people by saying short-term rentals are a no, but I think that the real meat of it is built into 139 in most of these articles, and people should feel comfort in that, because as we know, a zoning bylaw is very difficult to change. Thank you, Mr. Chair.
Sure. My comment on that is that 139, there has been no definitive itemization of what is in 139. And we would not be willing to even consider that until we see what is in 139. Because what you're saying is it all hinges on what's in 139. I'd like to see something from Mr. Giorgio about the introduction of the term vacation rental. And somehow or another, accessory short-term rental, the word accessory has disappeared from the lexicon of what we're discussing. So we can't agree to that until we see what's in 139, because otherwise it's meaningless.
So Charity, if I may, that goes without saying, right? We're trying to do this piece by piece by piece, and that's the only way to get this done, or we could just be talking about abstracts for a very long time and not accomplishing anything. No one is going to be asked to sign on to an actual complete zoning amendment that is satisfactory, understanding the law of compromise or the rule of, or the goal of compromise. But yes, it is all, I agree with you, it is all going to hinge on the substantive requirements placed in this new section 38.
Stephen.
So the problem with relying on an A is that the accessory use could be determined to be any use that is less than half a year, which I suspect you would be greatly not in favor of. So the best approach is, instead of relying on that A, is to put regulations in place like we're talking about here. I think that the A is not the protection that you think it is, because you're assuming it means what you want it to mean, and I'm suggesting it might not.
It's going to mean what is in 139, 38. And that will guide whatever we decide on accessory.
No, that's what we put into 139, 38 will apply, but if it's an A, then it also has to meet the others. You're now tying it into other things that might be in conflict with what you want it to happen, because that you are now saying, okay, other legal definitions now apply to this, which I think are beyond what you want that to be the case.
Well, we'll decide that later.
Matthew, wait, I'm gonna ask the planning director. Leslie, if you're on and would speak about just the generalities of what an A in the use chart would mean from a planning perspective, and as managing all that, I think that might be helpful.
Sure, I just need a minute to look that up so I can be precise.
Sure. I'll take a couple other comments from the group here, and then if you just want to raise your hand, I'll come back to you. Matthew.
Yeah, a couple things. So We get what Mr. Iverson, I think we get the idea, the concept and everything like that. A lot of it, like Charity said, I think hinges on what these regulations are going to be. And if we agree to them as a group, I think our group, we need to discuss it. We need to talk about it. We need to run it through our legal process. That's probably gonna be the last thing that we get to if we're agreeable and everything else. I mean, I also agree with Mr. Cohen a little bit. I think a lot of this, we have such a tight window here. I think a lot of this hinges on the zoning board of appeals and what's gonna happen there. I wish these could kind of be separate. It wasn't all kind of at the same time. Unfortunately, it is, and we kind of got to make it work. But yeah, we get the concept, we get the idea, but our number one goal is, we have a lot of people that have come to us, a lot of people that showed up at town meeting, and a lot of people that are counting on us and like our article and signed on. And we want to make sure we are protecting those people and protecting the neighborhoods. And so that is our number one concern, is to keep the hotels out of neighborhoods. And so that's, we're not trying to make this a hard process or anything like that, but that's what we want to make clear is that, and I'd like to hear what Leslie has to say and Mr. Giorgio to follow that up as well. So
Yes.
about the intention or extra consequences with it.
Okay, I'm gonna go to Leslie, okay? Leslie?
Hi, okay, great, thank you. I want to say, first of all, I completely agree with the description that Stephen Cohen provided of using the A in the use chart and why that's problematic. So, and I fully support the idea of the short-term rental not being a quote primary use, but it's all in how we put it in the bylaw. That's very, very important, especially when it comes to interpretation later by zoning enforcement officers, by building code officials who are by statute, zoning enforcement officers, by the zoning board of appeals, and just by the general public. I think whatever goes in to this article that everybody hopefully gets behind has to be very, very clear. So we're not, doing this again. So in the zoning bylaw, we have accessory uses defined in the definition section. And the definition is separate structures, buildings, or uses which are subordinate and customarily incidental to a principal structure, building, or use located on the same lot. So that's one piece of it. Then in chapter 139, section 15, we have a section entitled accessory uses. And that section reads, in addition to the principal buildings, structures, or uses permitted in a district, there shall be allowed in that district as accessory uses such activities that are subordinate and customarily incident to such permitted uses. So I think you all will probably agree with me that that's pretty vague and pretty open to interpretation. And someone has to decide what is the principal use, what is the primary use, and is the so-called accessory use customarily subordinate and incidental. So that's, very, very subjective. So that's why I'm suggesting, and Mr. Giorgio is suggesting, and others, that we not go with the A in the use chart, because the A in the use chart ties back to this definition of accessory use in the definition section, and it ties back to the section that I read that's on the screen now, chapter 139, section 15. I think that the best approach would be for whatever you're going to call it, the vacation rental or accessory vacation rental or accessory short-term rental or whatever that name turns out to be, it needs its own definition and its own, I guess its own accessory definition, which is what you all are talking about. But using the A is going to create a lot of problems, and I don't think it's going to achieve what anyone on this group really wants to achieve. I think you need to go with the Y, and you need to clearly define how the use is permitted in the zoning bylaw and in this new section chapter 139, section 38 that we're all talking about, whatever that turns out to be.
Thank you, Leslie. One of the barrage of emails that have been going on with this the last while, I saw one of the groups or somebody refer to as what we were just calling vacation rental as limited. I thought that was a good term for it. Might have been, I don't remember, but that was a good way of thinking. It would be primary, would be N, limited would be wide as defined by. Yeah. Charity, I'm gonna go to Grant and then, okay.
I just want to state a fact and a belief. The fact is that if we all agree that we can get behind this Y in the use chart, and create, what we do is we create a structure where we can all talk about the details, and the details are these things in the chart from point 2 to point 9 that we haven't agreed on yet. But if we can agree on this one thing, then all those other details, we can do some horse trading. But without the structural difference, with that structural difference in place, it's really hard to agree on those things. And now here's the part about my belief. I believe that if we don't develop a compromise article, that we're going to have 3 dead on arrival articles at special town meeting. So I really, really want to see if we can do this. And if we can't, then we can all fall back on our articles and try to convince town meeting that they make sense. But I'm not sure that any one group here has the votes to get past that 2/3 bar.
I agree with that. I don't think any article that's currently proposed has to get 2/3 vote, including the one that I've sponsored.
Especially yours.
I don't think,
Certainly given what happened in that.
okay, that's unnecessary.
We're good.
Sharing, but,
I'm gonna go Dave and then Jim. Okay. Dave Iverson.
Thank you, Mr. Chair. I just want to, and again, Leslie and John, please, if I'm wrong, correct me here. But I think I've heard a couple times people mention the process that's going on right now with the ZBA. And I think that it's really important for people to understand that the ZBA is not going to create a new definition. They're just going to interpret the definition that we currently have. Okay, so nothing is going to change in their decision. We are still going to have the same accessory definition. And as said before, and I'm just going to drill it home, that's why it's important that we create our own definition separate and boxed out from that accessory definition. And whether we call it accessory short term or whatever we call it, we have the ability to define it. Where with accessory right now, we don't have the ability to rework that because it's already embedded in our zoning bylaws, and it refers to many uses in our zoning chart that wouldn't be congruent with a short-term rental. And that's why it's important that we create a new definition for short-term rentals and define that in a way that addresses everybody's concerns. Thank you.
Thank you. John Giorgio?
Muted, John.
Sorry about that. I completely agree with what Dave just said. You know, from a process standpoint, I hope everyone understands that if this group reaches a consensus, what we will do is we will draft a 4th warrant article. Hopefully it will be an article that the planning board can get behind. I think it's very important that the planning board take a strong position on this issue. And we would add that to this new article to the warrant. And it would be similar to what we did with Article 60 at the annual. We would put the select board would put this compromise article first. It would be debated and voted on. And then hopefully the 3 citizen articles would be indefinitely postponed or passed over, take no action, whatever we decide.
Jim, and then Charity.
Yes, I want to say, I think in order to move forward tonight, we need to do some as-if thinking. The as-if thinking meaning that we have to all proceed as if we will come up with something that we can agree with, because otherwise we won't get to those details which allow us to know if we are getting there. So I think in order to move forward, we should all agree that we will do this as if thinking. We believe these regulations can be crafted. Let's try to. And in saying that, Tom, I just want to go back to your original question about number 2, which was legacy. And you asked if anyone had any more comments on it. I just want to bring up the concept of respect toward each other and toward our island and our people. And by that, I mean, we want to respect neighborhoods. We don't want them to be torn apart by STRs. We also want to respect the property rights of people who purchase something under different rules. And they will be changed probably by what we decide as a group, and I hope we will decide it. But in that case, I think some sort of sunset makes sense. We propose, I think, a 5-year sunset on multiple STRs. That's the only area where we are looking to think about a legacy. I think maybe Steve wants a 10. I think maybe Charity, if she agrees to this, and it'll depend on the other regulations, might be more toward a 5. But I just want to propose in this as if thinking that we sort of say maybe 5, maybe, and we can move on to other items. Just want to propose that.
Charity?
We cannot make a decision on one until all of these other elements are addressed and there is some kind of template for what we're going to do. And I also think that even in terms of legacy, we can't even discuss that until we get down to how many properties people are able to own. So I mean, you have some contingencies here. If we do this, then maybe we can discuss legacies in the context of whatever.
I would just note from after being on the work group for a long time and then going through this multiple times, that instead of the Y or the N, this does seem like a middle ground. A middle path forward, depending on how it's defined for all of us.
So I have a question of a legacy for John
Please.
Giorgio, which is, can you sunset in the zoning provision in this way? I'm not sure we can. But that's really a question for John.
So conceptually, Steve, the answer to that is yes. If by legacy you mean, can you have a provision that is in effect for 5 or 10 years and then goes away after that?
Yeah, that
Automatically, is that what you mean by legacy, or is that's a sunset?
Yeah, no, well, I think what Grant and Jim are talking about is allowing the people who currently have more than the number of STR uses than whatever number is adopted would be able to keep that in place for 5 years or whatever number of years. And I don't know if you can say, okay, you do get to have your legacy pre-existing non-conforming rights, but only for 5 years. That sounds legally not correct to me, but what do you think, John?
You would be delaying the applicability of the new bylaw
Yeah.
to a certain class of individuals who meet the sunset, who qualify for the sunset provision,
Yeah.
right?
But
I don't think that's, you see, this is the problem with new terminology. By legacy, do you mean grandfathering?
yes.
Okay. I don't think this is a grandfathering issue. I think it's a sunset provision. It goes away in 5 years, and I have seen zoning bylaws that do have sunset provisions.
Where the express granting of grandfathering can then end.
I'm sorry, Steve, would you repeat that, please?
Yeah, well, what we're talking about here is specifying grandfathering rights, but putting a time limit on. Is that legal? In other words, if I have 4 STRs right now, and we decide I can only have 2, and the bylaw says I can keep my 4 for 5 years, but then I have to only have 2. Is that legal?
Well, here's the issue, Steve. If you currently have 4
Yeah.
STRs,
Yeah.
in order to qualify for the grandfathering, or like, we can go back to using legacy protection, you have to be a prior lawful non-conforming use.
Yeah.
And so the question is that person who is currently has 4 STRs, is that a lawful use? And according to Judge Vey, depending on where it's located, it's not lawful because your zoning bylaw does not permit short-term rentals. And therefore, because it's not expressly allowed, it's prohibited.
Unless they qualify as an accessory use.
Correct. And that's why he said, zoning board of appeals, you go back and make that determination.
Right, so everyone who currently has a short-term rental that could qualify under the accessory use as a legal short-term rental could potentially have legacy rights that we can end or can't.
If they qualify as an accessory use
Yeah.
under the existing bylaw,
Yeah,
then they could continue. Because they would be a lawful pre-existing non-conforming use. If they don't qualify under the accessory use definition, then they're not a legal, lawfully existing prior non-conforming use. And they have no legacy protection.
right. So I think that if I understand it correctly, Jim and Grant's provision would basically say anybody who is currently over the number would be allowed to continue for 5 years. But that people who qualify in accessory use would be exempt from that sunset provision. Is that legally how this would play out?
I think that's correct, Stephen, yes.
Okay,
And there's nothing you can do about that.
yeah, that's right. It's not a policy decision, it's a statute.
Stephen?
Yeah, so I had one question and John raised some points, now I have a different question. So if we have STRs, which can be proven to meet the definition of accessory today, do they have legacy protection only from the maximum number of permits that a person can hold, or do they have legacy protection from other regulations also?
No.
And I'm talking specifically about what's in zoning, because we know that nothing is protected from what's in general bylaws.
So if you have legacy protection, the new bylaw doesn't apply to you. Because you would be a lawful pre-existing non-conforming use. It's not just, you wouldn't just pick and choose particular provisions. Whatever is in this bylaw as adopted, if you are currently a lawful accessory use, then you would continue with that legacy protection.
But just to follow up on that point, could you, if you want, could the town get around that by essentially having redundant positions in 139 and 123? Because 123 is not subjected to grandfather. Would that work?
Legacy protection does not apply in a general bylaw unless the general bylaw grants the legacy protection. It's unlike zoning in that regard.
Okay.
So then, to Stephen's point, you can, in the general bylaw, section 123, if we say you have to comply with section 38 of 139, then every STR is subject to the same zoning regulations?
You guys are really trying to make this complicated for me, aren't you?
Make it more complicated.
I think we're gonna get ourselves wrapped up in knots here.
I don't wanna adopt a rule that doesn't apply to anybody, right? That,
Yeah,
or maybe I do, you know, but I think it's cards on the, but I'm putting my cards on the table here that like, you know, people think they're adopting something and then we turn around and it doesn't apply to 1,700 people. What have we done?
Real quick.
Yeah, Jim.
Real quick, John, just to ask then, if for some reason the accessory definition is so lenient that everything is included, doesn't it seem likely that we should change to a general bylaw in order to not have everything be grandfathered?
Okay, so this is exactly what the short-term rental work group did. And that was one of the reasons why they did it. But that did not fly
maybe we,
because there was a group that said, no, we want to do it in zoning and we want to make it a 2/3 vote and we want it to be a 2/3 vote to change it. So, you know,
I guess what I would
you
say.
can't have your cake and eat it too, right?
Some of these provisions, we may want to put specifically either in both or in the bylaw for that reason. And I'm trying to be helpful.
Yeah.
Charity.
What happens if one of these properties is not being short-term rented at the present time? I mean, will they be permitted to be grandfathered, or because they are now no longer, or they've never short-term rented, let's say?
It's never there. They would never have legacy protection because they're not a prior legal non-conforming use. The use doesn't exist today on that lot
For that property,
for that property.
that one.
In your scenario, Charity.
Yeah.
So they would be subject to whatever you put in the zoning bylaw and of course, whatever's in the general bylaw as well.
Grant.
So, I just want to be clear that the current accessory uses as they apply to short-term rentals, if they are pure, true, short accessory uses, they're really not of a concern to our group because they're not the problems. They're the ones that have people living there on, you know, more days than they're renting them out. They're part of the community. They're not generally investor short-term rentals. So I would be okay with that. Now that may change with what the ZBA is doing, but it doesn't sound like it will. So I will stipulate that I don't mind providing legacy protections to people who have 2 or 3 or 4 short-term rentals for 5 years because and allowing anyone that's an accessory use to have them forever, because I don't think the people who have an accessory use right now are the problem.
Well, it depends what the definition of accessory is, but sure.
Yeah.
Dave Hudson?
Now you've got
John,
to,
please.
I'm sorry.
No, John, please.
You have to remember that in the ZBA proceeding, counsel for the wards have already filed a mini brief, I guess I would call it, in which they're arguing that the grapes will never qualify as an accessory use because of the definition, and Leslie did a great job of going through that for you. The accessory use has to be incidental and subordinate. And the grapes are taking the position, as I understand it, that means you have to reside on the premises, as that has to be, the primary use has to be longer than the accessory use. That's the argument. And so if you think the ZBA is going to solve this problem, the ZBA may find in favor of the grapes, but that is going to be appealed. Now, I say that with such certainty, maybe it would, I mean, I would imagine that that's going to be appealed back to Judge May. Because of the specific facts of that case.
I don't think that the ZBA is gonna give the clarity that anybody wants.
It's not. I said that the other day, and I continue to believe that. It is a mistake to think that the ZBA is going to solve this problem for you. It's not.
They're an adjudicatory board, not a policy board.
Dave Iverson.
And they don't want to make policy.
That's right.
I mean, talking to them, they do not want to be where they are. They want to enforce the regulations and the law. not-
And probably it won't be decided on June 24th anyway.
Dave? Oh, Dave took his hand down?
I don't know if he's having issues.
Ah,
Here he comes.
there he is.
I-
Hey, Dave.
I've had issues for many years, but I just, in an effort to recenter this discussion, I think that we need to focus on building the foundation here, and the foundation
Yeah.
is deciding what we're doing in 139. We as a
I
group,
agree.
we need to decide how we're gonna deal with this in zoning, whether we're gonna create our own definition and then have its own column or row in the use column, and then add the regulations, layer the regulations. But we need to decide on that before we can move further to anything else, whether regardless of what's going on in the ZBA, regardless if you think you should have 5 days or 8 days, all of those discussions happen after we decide on the foundation of our regulations. So I really urge us as a group to really focus on that right now, because until we decide how we're going to deal with this, whether, most people are favoring yes with their own definition, and I understand Charity's reluctance, but I think we need to get through this and decide on this before we can talk about the rest of the stuff we're talking about here. My opinion. Thank you.
I just want to push back on you, Dave, and say that since Charity can't decide on Y versus A until she sees all of the details in 139-38, let's work through the details of 139-38. And then if they are agreeable to everybody, then we can say, okay, yes or no, we're going to go with a Y on the use chart. We're going to go with an A on the use chart. Does that make sense to everybody?
With all due respect, Grant, if I may,
Yes.
I think my recommendation is you proceed with what the majority consensus is right now, and you agree to the use chart designation, and whether Charity and her group can ultimately get on board will come in the next couple of nights when you discuss the specific Section 38 regulations. I think we've got to move this forward. And there is, I agree, a consensus on a Y in the use chart with a new definition. And I think that's the premise you should proceed on. And let's get down to the real issue, which is what's going to be in Section 38.
I think we're saying the same thing, John. I just want to, everybody
Okay.
to walk hand in hand as opposed to being dragged along.
This is taken.
Okay.
Let's go.
So I think we all agree
I
that,
was just gonna say, there were bunch of complicated legal issues. That was all that thread, I think, was all gonna come up. We talked about that at the work group, so I think that was good that
Yes.
that came up and you guys had that back and forth on grandfathering, et cetera.
so I think we're in
Pre-existing.
agreement that the short-term rental with no further definition to it should be a prohibited use in all districts, right?
I'm not agreeing to anything, Steve.
Okay,
All
right.
right, not until we have.
You
some more
can't agree that, you
But
can't
through
agree
me-
that
through
short-term
me-
rental with no regulations should be prohibited?
Through
Yeah,
me,
I can
please,
say that,
through me.
sorry.
Yep.
I think Charity has made her position very clear, and I think it's time to move on.
Move on. Let's do the 2 through 10.
Suspended disbelief.
As if.
John, did you have anything to add?
Yes, Tom, I'm sorry. There was, and it's something, and I apologize because I did not mention this earlier. It's
Nope.
another legal issue that I want to put out there. We want to make sure that whatever zoning bylaw you come up with is going to have the most number of enforcement tools available in order to be able to enforce this bylaw. I know there was quite a discussion about enforcement and how would this be enforced. You know, right now, under your zoning bylaw, you only can, basically, you have a $300 fine. And as I indicated, we put in the general bylaw this $5,000 civil penalty. And that comes right out of the new short-term rental law, 64G. The Attorney General has approved that in the general bylaw. I am recommending that we add language to the zoning bylaw to make it clear that that enforcement remedy, the civil penalty, is available for the violation of any violation of the zoning bylaw. And you'll have both bases covered.
Everyone okay with that?
So moved.
Yeah, I agree with that, and I will follow, John. Could that also be for revocation or non-renewal of licenses?
Yeah, that did come up the other day. That's a good point.
That's already in chapter 123.
No, I mean to tie it to zoning violations too. Is it already in there?
Oh, you mean if you violate the zoning bylaw, would that be grounds for revocation
Or
of
not?
your, of your certificate? Is that what you're asking, Steve?
Exactly, yeah.
Yeah, okay, we can add that to the general bylaw.
Well, that answers the question from the parking lot.
Is it, that
Charity?
you're going to add it to the general bylaw, or you're going to add it to the zoning?
It's in the general bylaw already.
John just misspoke. He meant he'll add it to zoning.
Zoning bylaw.
Yeah.
So what we're going to do is we're going to add in the general bylaw that a certificate can be revoked if they are in violation of this new chapter 138 of the zoning bylaw.
That's right. Yeah.
And in the zoning bylaw, we're going to add a provision that says the zoning requirements of 138 can be enforced through the civil penalty procedure. And then I think you've got both bases covered.
I think that is very strong enforcement.
Very
Lots
good.
of the licenses, the strongest.
Very good. Grant, on sort of your thread you were pulling on before about kicking off the conversation, do you want to go kind of start on your chart on a provision, or?
Do you want to just start at the top and work our
Sure,
way down?
okay.
We've already
Great.
sort of hit on the sunset legacy rights. So it sounds like that's okay with everyone.
Well, I suppose it depends what you're applying it to. Are we applying it universally, or are we picking and choosing? So if you're saying that
We're just saying bow
cottage
tie.
colonies can continue to have multiple licenses forever, but some family who had a couple of properties can't, I don't love that.
I think we were moving to exempt cottage colonies entirely from this, which we think is appropriate, which we did last year in the STR work group
Yeah.
plan. And then with individuals, the only sunset would be about multiple ownership, and again, for the reason of respect that I mentioned earlier.
I guess what I'm saying is that's the same issue, the multiple property or multiple unit. But some people can keep their multiple units and others
I don't
can't.
believe it's the same issue. A cottage colony is an entirely different beast. It's a seasonal thing with often on one property. So I really don't think it's apples to apples. I think it's apples to oranges.
Grant,
Our provision is just about people being able to hold on to their multiple properties and operate them as short-term rentals for a period of 5 years so that they can get their houses in order and convert back down to one per person. So a couple could have two.
John,
I'm sorry, on the cottage colony issue.
Yep.
We looked at that. And if I take you back to November of 23, the general bylaw, that included a definition of cottage colony and a definition of hosted stay. And there was a specific provision that said those two groups would be exempt from certain provisions restricting the operation of a short-term rental. Is that what the group wants to pursue now in the zoning bylaw?
Grant and I do, I believe.
I'm sorry,
If it's in 123,
it's not in 123. It was proposed in
Oh, okay.
123, but that did not pass.
I think that it makes sense to do that. Does anyone agree or disagree?
I just want to ask a question. I mean, you're separating out a cottage colony, or what about other property, probably families, who can demonstrate that they rented short-term before 1972? What are you going to do about those?
John, do you have any thoughts on that?
Yeah, I'm sorry, Charity, what is the concern you have?
Well, we had this in our article to begin with, and then you suggested that it wasn't necessary because there were other appeal options that were open to people, and this seems to just be dealing with the cottage colonies, and we originally had that in our article. But then the question came up about what about people who may have been renting short-term 1950, 1960, and are they going to be bound? And why you exclude cottage colonies? And
If somebody has been, if it's not a college colony, if it's not a hosted stay, but someone has been doing a short-term rental since, I guess prior to the adoption of zoning, is that what you're saying, Charity?
Yeah, that's what I'm asking.
So if somebody can prove that they were operating as a short-term rental prior to the adoption of zoning, wouldn't they be a pre-existing lawful non-conforming use? Yes, they would be.
But still subject to the general bylaw. We're talking about.
But they would still be subject to the general bylaw.
Cottage colonies only get exempted. I don't have a particular problem with that, but it is odd that these are the only properties we care about exempting from everything.
Yeah, it sounds like a carve out.
It's, yeah,
It is a carve out, but what you're saying is this certain group of people who would have more number than others is okay, but other people who historically have had more can't. And I just don't think it's fair.
And the only difference is that there's no tax lot line that goes between the dwellings. Somebody could have 6 of these dwellings and it's just on a very large lot that they never subdivided. The only difference.
I also think that we've said it before, the number of people who would exceed that are like 4%, right? It's
Right.
a super small number.
So what do you propose?
To treat them all the same.
Okay,
So exempt all those people
That we're,
and then they go away through attrition.
they go away through attrition, right? That if people, in other words, the exemption should only be for people who prior to now have more, and those will drop off. That's a simple and fair way to do it. Or to exempt them all the same.
are we still talking about the 5 or 10 year sunset?
You know, you got.
Only if that applies.
Only if it applies to everybody, which I don't think it should actually apply to everybody. I don't think it should apply to anybody, but I think it should be fair. Like, I just don't see why some people get exemptions and others don't.
Charity,
I'd like to ask a question about that, because let's say that you have the Corfish cottages.
Yeah.
What happens if they sell one of those?
They'd have to sell through the covenant program, I would guess. I mean, I don't know the Turkish cottages exactly, but I don't think it would, there's 3 acre zoning there for sure. So I don't know how you could draw the lot line in such a way that you could do a conventional subdivision. So you could only sell through the covenant program.
Yeah, although if they predate 1956, they could do a 4181L and each of those could be its own lot. I don't know the details, but I suspect it might apply.
Jim, if I remember back to the work group days, this is exactly why, like, there are all these specific ownership scenarios, and it was impossible on our time frame to catch them all.
And I respect what you're saying about treat people fairly. I do think it's apples to oranges. I may be wrong on that, but I think they're less developed than these houses in the middle of town or whatever. And there's a tradition. And I think it's important to respect that tradition. I don't think it's worth wasting a half an hour on,
Yeah.
but I do not want to use the issue of fairness in a way that may not apply because it's apples and oranges, although I respect your idea of fairness, but I'm not sure that that's exactly a cogent argument. So I'm just talking about tradition
Okay.
of how some people have had these cottage colonies, and I think they're different from the STRs in my neighborhood.
So I guess where I think we are is that there's a consensus that people who, on the number of allowable SDRs, that there should be some legacy provision for that. And the disagreement is just on whether or not that would sunset and who that sunset would apply to. Is that at least fair enough?
No.
No.
I think it's a whole different issue. I may have misunderstood you, but I just think it's a different issue that should be dealt with differently. And we do need to come up with a fairness for the legacy issue. I personally think the 5-year is a good compromise between all of our positions here, and I wanted to sort of suggest that as something to maybe accept for now and move on, but I don't want to shut down any good ideas.
Jerry, Matthew had his.
Yeah, I just want to say, I completely agree with Jim on that. I don't think it is apples or apples orange. I mean, really, it's, and the loophole around that, everyone's gonna try to figure it out, but then they split it up between family members. And what's Peter Schaefer's kids have? 8 houses on the island, and so what is he gonna do? He's gonna stick 2 in his kid, 2 in another kid's, 2 in another kid. I mean, that's, unfortunately, that's gonna be the loophole, unfortunately.
Not, Matthew, not to jump over you, but I don't think we should be naming individual
Right.
situation. Yeah, no problem. Okay.
Can we start working with what the fundamental ownership right is going to be, and then move to these extraneous
Yeah, good idea.
Okay.
Please.
Good idea.
circumstances?
I'm gonna go to Dave.
That's fine.
God, and listen, I hear what Charity's saying. And I agree with her, but I just want to jump in on the college colony just one last time. Is you're comparing someone like, let's say, Copley Group, right? Who had 5, 6, 8 houses, however many had, very well appointed, all winterized, to small cottages that aren't winterized, could never fall within the accessory use because it's a family cottage colony that there's no way to live in. So I think that to compare multiples to a college colony is, as Jim suggests, apple and oranges. And I'm sorry to belabor the point.
I guess what I would say is whether or not we can reach consensus on a sunset provision might depend on the rest of the terms. So like, you know, at the end of the day, we are all going to accept some terms that we don't like.
That's right.
And I guess what I would say is that's not the hill I want to die on.
Right, let's do the as if thinking for now, you
Yeah,
know,
so.
as if we agree, Stephen. I hope we will.
So let's for now put a pin in the idea that those are, the being over the number is allowed with a 5-year sunset, and we can come back and see if we get on other things, if that's where we end up.
Yeah. that's
Because it's
perfect.
not, you know,
I agree.
I just have a question for John. I mean, would not these properties be permitted to go to the ZBA?
John?
Yeah, I'm sorry, Charity, would you repeat the question, please?
Would not, because I think what you were suggesting to us when we presented our article was that there are other means for these outliers to appeal, and would these properties be, and their owners be able to appeal to the ZBA if they're offended by these rules? To get a, you know, a waiver or something.
only if we put standards under which they could apply for. They could apply for variance, which they would get.
Okay, so right now we're talking about a provision that would limit the number of STRs to 1 per lot. But there would be a sunset provision that says if you are currently operating 2 STRs, you're allowed to continue that for a period of 5 years, and then you'll lose that. Then that allowance will sunset.
We're really talking about owning more than one STR, like having.
Owning more than one, okay.
Okay, separate, they're probably separate properties, but anyway, that's the
Okay,
issue.
so okay, you're gonna limit the number of STRs any one individual can operate to one. But if you're currently operating two, you may continue to do so for 5 years. Is that what we're talking about?
Well, we didn't agree on the numbers, but that sample.
Yeah, yeah.
It's an example, yeah.
I would write that down, and you can.
Do we have, is the outcome of that? That the sunset, I mean, it should be that the outcome is that they have to dispose of one of the properties. Is that what we're talking about?
No,
Sunset?
They don't have to dispose of the
Wait.
property, but after 5 years, I'm sorry.
No, John, please. Go ahead.
They, Charity, they don't have to dispose of one of the properties. They could dispose of one of them. They just can't short-term rent.
Okay. That's
After
fine.
5, they can only short-term rent one property, but they'll have a sunset for 5 years that they can do whatever they're doing now, they can continue to do for 5 years.
I don't think that we should get bogged down in what I'm gonna say
No.
right now, but we may want to consider an exemption for inheritance. So that if you are inheriting a property due to death, that we are not immediately applying that standard to you. But when we're working on that, we're further, way further along.
I would move on.
Let's move on to number 3 is what I
Yeah,
want to
I-
suggest.
We can write that down and change
Yeah.
it later.
Exactly.
Leslie, you had your hand up. I just want to make sure that you didn't, if you had a comment.
Okay.
Sorry, I have too many screens open. I couldn't get to the unmute button. I just thought for a second, the direction of the conversation was going towards some sort of use variance, which our zoning bylaw specifically does not allow. But then the conversation took a bit of a different turn, but I think I did hear someone say that if you want to have a provision for someone to apply for relief, then that needs to be spelled out somehow.
And is that to the ZBA?
Yes.
Okay.
Well,
Yes.
if it's a waiver from chapter 123, it would be from the Board of Health, but if it's from the zoning code, it would be the CBA.
That may be the way to go.
Number 3, please.
So I'll just kick that off because
Sure.
our proposal was for one, but we're willing to compromise on allowing someone to run 2 separate short-term rental contracts on a single lot if they have a primary and a secondary dwelling. And it seems like we had reached some consensus on that. Are we there? Are we gonna?
So I just want to clarify, so one person can have 2 certificates of registration if they're on the same taxable lot.
Correct.
And then my partner could have another one on a different lot.
Correct.
Okay.
So why not just do 2 certificates of registration per person?
Because then
Then.
He and his partner
then
could have
partners
4.
And that's not the goal.
Yeah.
The goal is 2 people can only have 2 taxable lots, and they could have maybe up to 4 certificates of registration if there was a house and a cottage. But it's 2 properties. So we're thinking about
Yes.
properties.
Yes,
Not about dwelling.
right.
Correct.
And the only exception to do more than
property
one,
per person.
the only exception, absolutely, Stephen, would be to do more than one is if they're on the same lot.
Charity or Matthew, you both had your hand up.
Yeah, question, Steve, maybe you can answer that. How often does that happen? How often is there 2 houses on one lot that they're running out to 2 different rentals?
I don't have the data on it, but I don't know.
I know
think it's
2
very
people who
common.
do it.
I don't think it's very
Yeah.
common.
Yeah.
Also, just thinking back to the cottage colony discussion, if we define the CORs, or define the limit here as 1 taxable address per person, then that covers the cottage colonies, because they're, you have
Oh, good
5 or
point.
6 of those all on one lot. So just limit 1 lot per person. Sorry. And we solve that issue.
With no limit on the number of certificates of registration.
Right, because we know that zoning doesn't allow for 3 and 4 and, extra
yeah, or it does, but we're prohibiting.
We're prohibiting tertiary dwellings elsewhere.
Right.
So-
Sure.
We'll just go through scenarios here. Let's say you have one person living in a primary dwelling.
Mhm.
And they have a secondary dwelling on the property. 2 certificates of registration.
No, well, yes, if they
If
want,
they want to STR in some way their primary.
Right.
And they want to STR their secondary. They have to have 2 certificates of registration. And those 2 properties will be bound by the change of occupancy rules. That's what we discussed. So that they would, each one of those certificates would be bound by 7 and
Yeah, or
whatever.
6 or 7.
6 or 7 in
changes
the
of
summer,
occupancy.
and,
And then
those are the 2 that they
Yeah.
can,
We would have to work that out, but yes.
okay, I mean, these are the details.
Yeah, those are important
That are
details.
very, very tricky,
Yeah,
and
that's right.
by what you're suggesting is, 2 dwellings, 1 person, 2 primary. Let's say that Joe owns 1 house and Jane inherited another.
Mhm.
They would have a certificate of registration for Joe's house.
Mhm.
Joe would move in with Jane, and however they worked it out. But each one of them could have a certificate of registration from each of those properties.
Right.
1
so-
person, 1 taxable lot.
Right,
That's
whether or
it.
not they're
Yeah.
married,
Not 2.
whatever.
Right.
Thank you.
So I guess I have a question for John Giorgio, which is that if you have like a married couple or a family that owns the property, is it okay to essentially establish, okay, I am the designated STR person for this address, and my spouse is the designated person for that address, regardless of the fact that we might both own.
It's a good question. It's a good question.
Can I, before John comes in, our language says person or entity, and by that, it means an LLC or something like that. So if a couple had 2 separate LLCs, they could, one could run one else LLC and one could run the other.
That could separate it.
Yeah, I guess what I'm wondering, but if it's entity, then let's say you have, like 2 brothers who want to buy a house, but
Good luck.
yeah. No kidding. Let's say you have 2 brothers
I do.
That like each other.
that like each other and they want to buy 2 STRs.
Mhm.
Like, as long as one person is the designated person for one,
Yeah.
and one person is the designated person for the other, and neither of those can have another. It
Right.
doesn't matter that the underlying owners might be a group of people. Is that what we're talking about?
Yes, I'm pretty sure John Giorgio last year told us that would be exactly what you could do, but I don't know if John is.
John, do you have any comments on that?
Are we talking about 2 STRs on the same lot?
No,
No, we're talking about applying the limit to a person, sort of as one taxable lot per person, with the idea that we are then not worrying about who the underlying owners are for that purpose, because you could have spouses owning both properties and, together, or families owning both properties together, like if it doesn't matter who the people are, as long as we're designating that like STR property to one person. I think that works.
One,
But
I think the designee does have to be an owner,
Yeah, it has to be an
Yes.
owner.
Property.
Well-
Right, but we're not
No.
applying, we're not talking about applying that designation to everybody who happens to be an owner. So that if there are multiple owners, they can each have one, if my wife and I own 2 properties together. Through an LLC or as a married couple or whatever, we could still each have 1 property. The fact that we happen to own both doesn't matter. Is
John?
that what we're talking about?
that's what we want. Yes.
Well, would that second person be an operator as opposed to an owner?
Well, that's part of the question for you. I'm wondering if if we needed just a different term for that limit potentially. Like a designate.
I think we just, so I think you solved it. Each
Yeah.
person operates-
So-
Yeah, right, there you go. Each is an operator for a different one,
Right.
even though they own it together, own it
And
together.
you can only be an operator for a property of which you have some ownership interest.
Yeah,
Does that work, John?
I think it probably would work. I'd want to see that in writing, though.
Okay,
If someone could maybe, take a stab at writing down what it is you intend, and then I can review it and wordsmith it.
You want me to do that now, John, or do you want it tomorrow?
No. I think, if you could send something to me, I'll take a look at it and I can let you know whether I think it works or not.
thank you, Grant. You can
You
do
got
that.
it.
We'll take a step at a
Grant,
time.
you can do that in the context of your bylaw, right?
Yes.
Yes.
Yeah,
No,
yeah.
Charlie,
I think this is something that will benefit tremendously if it gets any legs by examples.
yeah,
Okay, and we
Yeah.
did that in our article.
you did a nice job with that too.
Okay, so
Yeah.
that will clarify things. For example, I'm listening to this, what's to prevent a couple from putting a property in the name of their child, who may be 18 years old? And then, how would that work? Would they just have maybe the parents,
That's a-
parents would be the
Could I
operator.
just say, that's the Palm Springs example, and in Palm Springs, they decided, yes, they can do that. It's one per person, but if you have an 18-year-old daughter, she has one, maybe the mother has one. I mean, that was the only solution they could come up with. If a family can do that, they will.
well, I think that's the point that they would have to be an owner, but they would have to be
Yeah.
the. owner.
Right. And you could
That-
designate,
That could proliferate.
you designate
number of
one
people.
property, Charity, you designate one property per person in the family. And that Palm Springs found a way to stop that, nor did they want to.
Great, if I can speak, people
Yeah.
are gonna game this, whatever we do.
they
Sure,
are.
sure they are.
You know, and you can make 100 examples of why this is gonna work and that's gonna work. I think I would write this concept down and move on to the next one, because
Yeah.
whatever we do, there's gonna be a
That's right.
loophole. It's gonna be,
Everything.
it's gonna be.
Right.
It's,
The concept of.
What-
trying to limit-
Stephen Miller, Grant Golden,
with due respect, it's not a loophole and it's not gaming the system. It's an allowable use.
Well,
It's something that we're not trying to punish people for trying to make their way on Nantucket. It's hard enough for
I
everyone.
wouldn't call it, look, people are gonna use the rules the best they can.
And I hope they do, because it's hard to live here. And we need to give people the ability to create generational wealth and to do the things they need to do as a family. And so if a family of 5 has, 2 partners and 3 kids, and the kids are all under the age of 18, and they create trusts for each of those 3 kids, and those 3 kids can use that short-term rental to pay for college, more power to them.
Yeah, but effectively, 90% of your people are gonna be just regular
Right.
people that would end up with either 1 or 2 per couple.
Correct.
In nearly every circumstance.
That's
Right.
right.
Yeah, the
That's
number
right.
of 3s and 4s out there is very small.
It's very-
It's a couple hundred.
We all want to join those families, but we haven't been asked to.
Yeah. It's not, yeah.
Number 4.
So wait, I just wanna say.
Yeah.
That's a big one.
Yeah,
You were at 5 like 2 weeks ago.
See?
Yeah. So, I think
We haven't voted
there's
yet.
a lot of progress.
Okay, number 4. What is number 4, Grant?
4 is to limit the number of STRs per lot.
Oh, yeah.
And I think what we all agreed was that cottage colonies are exempt. And the one STR per lot unless there's a primary and a secondary.
So I think what we do is the opposite is, so you can have unlimited STRs per lot and then prohibit the structures that can't have them. No tertiary dwellings, no inclusionary housing, no non-dwellings,
No dorms or, yeah.
yeah,
No
no
apartments.
no
Apartments is a different-
Stephen, may I ask?
Apartments is tough. Apartments is tough.
Yeah, but Stephen, may I ask,
Those are- yeah.
is there a disadvantage to saying one or at most two? I mean,
Well,
why
maybe
is there a
cottage
problem? Why do you need
commons
to
are-
say unlimited? Because I really think we've got to go a different direction with cottage commons. But so why not just say one or two? What's the problem with that?
Well, if you're exempting, so there are properties that legally have three dwellings on them now that are pre-existing non-conforming. Would you be taking that away? Because I think those are older than 1972 by definition. You know,
His way of doing it is, and I don't mean to argue with you, but his way of doing it is a little more seamless. Because it allows us to say, you can have unlimited STRs on a one taxable lot with the following exceptions.
Yeah, well,
Right.
the reason I don't like it is I think there might be consequences that we can't
Yeah.
figure out.
I mean,
And I don't trust it. I mean,
Well,
I'm not saying I
okay.
don't trust Stephen, I trust Stephen, but I don't trust that thought.
Jim, I think that it's fair enough to look in the details on that, but there are situations where you have legal lots that are split up as condos where people have separate legal ownership that you might want to look at. There are lots that are, where you have like multiple apartments over commercial structures, where these people are all unrelated, they've all bought condos. I don't know that trying to limit the number of STRs on the lot can have unintended consequences, whereas prohibiting where you can't have them is sort of
Yeah.
easy to do.
But when we think about churn, if you simply say one, and if there happen to be two, you can have two. I think that's a good approach to churn. And I just don't think we want to open that up door. Now, again, this is not a hill I would die on, but I'm worried about it. There's something about it that just worries me.
Is there someone who can look into the numbers and figure out how many exceptions there might be in this?
So
situation?
nearly every lot has only a primary dwelling and a secondary dwelling, and we're gonna ban it in tertiaries, and we're gonna ban it in inclusionary housing, and it's already prohibited in
Covenant homes.
covenant homes or affordable restricted homes and timeshares. So then you're really getting into condos and apartments where there might be more than one per lot, where there definitely is more than one per lot, but generally those are separately owned. And I think we're getting into a situation where we are discriminating against people because they happen to own, one of the apartments above a business or something.
Are we allowing STRs in apartments? I'm trying to understand that.
We're not currently prohibited.
That's not a lot.
No, I mean,
number 10, that was my question too, because I think that's something that we
if
should
you
not
have,
allow.
if you have an apartment above a commercial business, right? Why would we say you can't have?
Well, would you have more than one? I'm gonna go to Leslie.
I think that, and I don't have them handy because we weren't gonna talk about the regulations, but I think the rental of short-term rentals in apartments and multi-unit buildings is in chapter 123 already, so you may not need to address it in the zoning.
Leslie,
Yes,
we had added it into 123 for the November special town meeting,
Mm.
but that was not passed.
Oh, okay,
So, in town, nearly all of the dwellings are upstairs, right? Those are by
Yeah.
definition apartments.
We come back to this.
And a lot of other ones would be deed restricted if they were in affordable housing.
So, yeah, if we do want to move on, I
And
would
my-
say this is not a hill to die on, but there's something about saying unlimited that just
No.
I get what
just
you're
doesn't
saying.
sit right with me, and I just don't think we should go there, but however, let's move on.
Like why?
Well, how about we say we agree on, yes, primary and secondary, and we'll look into the other
Okay.
options.
That
Yeah,
sounds
that's
good.
right. That they're
That's good.
allowed in primary and secondary dwellings, and we'll look at other options.
The other thing is,
That sounds good.
you could just say any other request go to the ZBA. if you want.
Oh, I do not think you should be doing that.
Susan will not like you.
No, because you create uncertainty and you're creating like constant.
Okay, just say one or two. We'll say no more than two. Leave it at that.
Yeah, why wouldn't you say no more than 2 STRs per lot?
Yeah, I like that.
I like that.
Because there are currently lots that legally have more than 2 dwellings on them. And in a lot of cases, those dwellings are legally owned by separate people because they're like commercial units above, or there are residential units above commercial. And I don't know that we would you know, whoever goes first gets it.
Are they in commercial zones though? I mean, if these are commercial.
by definition.
residences,
Yeah, they have to.
But aren't we excluding the CI district?
No, that's commercial industrial, I'm talking about,
Right here.
CN, you know,
This place right over
downtown,
here.
Mid-Island. There's all kinds of districts where you have, commercial on the first floor and apartments above, and I don't know that we wanna tell people, oh, because you have, like, we really need to stop the churn above this retail store, right? Yeah, or only two of the people can do it, and the third person who went last doesn't get that, right?
There's an apartment building, on Cliff Road that's right next to a hotel. And it's not a hotel. And it's not, I don't think most of the units are short-term rentals, but some of them are. They're all independently owned. It looks sort of like a big house. But there's
It's a school.
no, it's, anyways.
So, I mean, by
But
definition,
but it
those,
seems
those uses are.
most of the
in-
definitions, I'm sorry, is it all right?
I mean, by definition, those apartments or condos, wherever they are in semi-mixed use districts, all right?
It's just for the audio, Jim, so that
No.
those listening don't get crossed.
Um,
Yeah, Jim and then Matthew.
Yeah, it just seems that we don't want to encourage STRs in close-knit apartments. I mean, we haven't really dealt with this issue, but I know we tried to last year. And so I would like us just to table this and say, like, I thought that was a good suggestion, one or two, and maybe we'll look into more, but that, like I said, for both me and Charity, it just doesn't sit right, and I don't know why exactly.
We'll have
but-
time over the weekend to dig into this and figure out, you know, how many lots are.
It occurs to
Have a
me
good
that
time.
that a building or
It's
lot
a
that
hobby.
has more than three, or has more than two dwellings, probably has their own association, homeowners association or condo association, and they can deal with it on their own. If they want to regulate short-term rental. For instance, the property that I'm referencing at 8 Cliff Road, I know they have minimum stay length of 2 weeks. And there's also a maximum number of contracts.
Yeah.
That's a good point. Yes, Matthew.
So- Trying to move past this, could we say 2 per lot, except for maybe the town commercial districts, and then outline those districts in there? For now, possibly, because
Well, I
that's
mean-
kind of what it sounds like, a lot of these buildings are gonna fall in those town commercial districts.
Some will be country.
Mixed use districts, yeah, but I mean, by definition, those apartments are not primary, a lot of times they're
Those
not
are the
primary
only-
and secondary dwellings.
Those are the only places apartments are allowed, are in the town.
So the one I keep referencing, and maybe I don't have the details right about, like say, but I know this building exists and there are at least one short-term rental there. That's in ROH.
I got a letter from somebody on Union Street and they are in the same situation. They have 5 units in a residential compound setting and they have a association. Oh, that's, I don't know what it's all this. But I don't think we're gonna solve that right now.
Yeah, I think we should park
Move
this
on.
one for now and then maybe take further consultation from Leslie and her department.
I would also encourage all of you to go back and look at the general bylaw article that was presented at the November special town meeting. There were a lot of good things in there and you may want to start looking at that as a way to go. For example, that general bylaw prohibited short-term rentals in apartment buildings or townhouses.
Sounds good.
Yeah, I don't agree with that at all, because why are we discriminating against those people? Why can't they have the same property rights as other people, especially if they're in a district that might have all commercial uses and other intensities already?
Matthew?
Yeah, I understand, but my thing is, we have a hard enough time retaining people in this town, and those units generally are the ones that are at the lower price points and more attainable for workforce people on this island. That's why I would like to see them prohibited in areas like that, because that's where you're gonna find a police officer and his wife,
Which is-
able to afford something at a 1.2 price range instead of,
I don't disagree that those are the most affordable units, but I would agree, but I would suggest those are the people that might need a little short-term income the most also.
Can we go on to?
Yeah, Jim, you want to read the next one? please?
Oh, sure. Well, so this one is about number 5. The idea to limit the number of STR leases on one property at one time, cottage colonies exempt. We had sort of among our groups, one per dwelling unit, one or per dwelling unit. And Grant, can you explain the compromise? How did that
I didn't
work?
get that.
It's the same question we just talked about.
Same question.
Right, it's one or two if you have a secondary.
Yeah.
dwelling.
And so we could just sort of, I think,
So we're saying
Move
they
on.
can be allowed to be rented separately because we've addressed it by the one person per property.
Right,
Yeah.
Okay,
yeah,
then I think we're in agreement.
I've seen examples of people that have two dwelling units on a lot. They don't live on that lot. They live maybe next door or across the street. And sometimes it makes sense for them to be able to rent those two dwelling units to two separate parties.
Is that, each one has a separate license?
yeah.
Yes,
And
but
Different
each
DOR.
one would be governed by the changes license.
yes.
Yeah,
All right, we're getting somewhere.
Okay.
okay, great.
Okay.
I think our price point prohibits a lot of that as well. So a lot of people don't want to pay $10,000 for a week. I know if there's somebody staying above the garage as well.
Jim, you want to read the next one, please?
Okay, thank you. Number 6 is to limit the number of STR leases, and it could be per year. It could be just in high season in July and August. It could be a limit outside of July and August. And it could be a different number of leases or waiver for this or that, for X. This is one where we probably need some discussion. It looks like the charity group has 8 per year limit. The Cullen group has in July and August, 6 or maybe 7. I think you said, Steve. No limit in the shoulder and unclear about the other
You need
leases.
to expound on letter C, because I totally forgot what you meant by that.
And Grant's group has July and August, six changes of occupancy in July and August. No limit in the shoulder season. C is unclear. And this seems like the discussion of should the shoulder seasons be unlimited? Does that help the shoulder season economy, and also does that not cause undue churn and
That's a good place
disruption?
to start the discussion.
Yeah.
And that's sort of the reason, Charity, why we had no limit there was we felt that, living on Nantucket for as long as we have, 42 years in my case, we don't feel there's that much disruption in the shoulder season. We see a lot of weddings and the people look happy, but we didn't know why you wanted to limit it per year and not allow it in
Well,
shoulder.
because of stories from people who are affected by short-term rentals right next to them, for one thing. And then regrettably, these are not families. They are more than likely party people. And they can be very disruptive and far more than, couple parents and 2 kids. So that was the rationale, because they come for, they have bachelor parties, bachelorette parties, and they can be very wild. And we just saw what happened at the wine festival. In the Current, one guy just passed out in the wrong house. So I mean, I think there's that, and it can be very disruptive, and that's why we put it in there.
Matthew.
Yeah, I respectfully to kind of disagree with that point there. I think we see more problems in the shoulder seasons than we do in the actual summer because of that. It's the bachelor parties, not all the private clubs don't allow weddings in July and August. And so that pushes them obviously to the shoulder seasons. And that's where we see the majority of these problems, fig hours, all of that. Give you a story this weekend, or it was a Memorial Weekend when we saw the Current. I think it was Memorial at the Wine Fest, but one of my drivers who lives in Park Circle said they were with their kid during soccer, had soccer with their kid off island, came home on the last boat and found some girl passed out on the couch. they called the police said that was the fourth call they had that weekend with somebody else inside of their house.
Yeah.
So, I mean, who's that?
So that's the reason, and,
So
and
that's, yeah.
we have
that's-
had that happen in our house too, in the shoulder season. I admit, once or twice, someone has banged on the back door and then passed out on the back steps. It's not pleasant. But,
those are friends of your kids.
they weren't friends of our
It happens.
That's a good, well, let's not go into that, Stephen, okay, please. But anyway, maybe there's a compromise where, you know, we do believe in the 6 in July and August. Could we come up with a number like 12 or 14 for the total year? I don't know. I'm not sure of that, but I wanted to suggest that, but I think I'm cutting off Stephen, so Stephen.
So, charity and that's 8 weeks. 8 changes in turnover would primarily be used by most people in the summer, because that's where the money is. And then there's essentially no short-term rentals in the shelter season. Their article entirely kills short-term rentals for the shelter season, right? I mean, there's no one who's gonna say, I'm just gonna rent in the cheap weeks. So I could not see that getting supported town meeting at all. Never mind 2/3 vote. Most people want to see a shoulder season here. And frankly, I think that there are other ways. There's always some bad behavior, but I don't think you cut off your nose to spite your face. There's just a different intensity in the summer. People are spending so much money. They gotta get all their fun in. They're gotta get everything in, and it's just like the intensity of the summer is just different than the shoulder season in my observation. And I don't think that limiting the number of turnovers someone can do in April or June is solving the problem that most people are concerned about, or October or November. But I do think that in the summer, limiting churn is probably one of the most important goals we have.
Charity.
I agree with that. And I started thinking about this. And I wonder whether we could have 2 components. One is, and here is where we have to decide. We say July and August, commencing July 1st. And ending by August 31st, so that there isn't a lot of bleeding out into those other weeks, because somebody could have a rental that would start on August 15th and it would go to September 15th, I suppose. So I think there has to be some limitation there, but on the other hand, and once that number is decided, whether it's 6 or 7, then I think we could go to a number per calendar year and expand on this. And just say, okay, let's say we pick 6 in July and August.
Yeah.
And then we say 6 more in the shoulder season. So then when we say 12 per year, calendar year, that has to be, I mean, given some of the stories you've heard, I mean, I think that that gives the owner a lot of flexibility about how they want to rent.
Grant.
Through you to Steve, putting on your real estate hat, does that jibe with? Is that more or less, is that more or less than what people normally have throughout the year?
So 12 is high enough that it's not going to affect most people.
Mhm.
But it's going to be crippling for a very small number of people. And those people are very hands-on owners.
Oh,
I find they're not they're people who live in a house and rent their cottage, and they treat it like a business, and they rent it really hard throughout the year. And I don't think those are the people who are causing the problems. I think it's the people who want to use their house in July. And so they're going to take any weekend they can get from Daffodil through Memorial Day and any other time in between. And those are the people who have less oversight over their house.
Yeah.
And I'll just make a point that NAREB as an organization accounts for only about half of short-term rentals on the island. So I don't have great visibility into what happens in owner direct rentals, but Air DNA tells us that there's a lot of that. So.
One of the components in our article that did not make it up to Stephen's list is exemptions for year-round residents who are on the property. Live there and they're gonna rent out their secondary dwelling.
And so, and I think that's great, and that would solve the issue for at least one particular homeowner that I'm thinking of. But Jim, in your case, years ago, when you rented the house next door to yours.
Yeah.
I would say that it wasn't a cottage, it wasn't on the same
Right.
taxable lot, but it was
Right.
essentially the same thing.
Yeah,
And you would have deserved that same protection.
and we probably averaged, and we had, our rent was, like $4,000 a week, even in summer. It's a modest place. But we probably rented out about 16 to 18 times a year because we did a lot of shoulders a season. We even did long-term rentals in the late fall too, to people from the college who came, but and those weekend rentals were very important because it all added up and paid for the taxes and mortgage and all that.
Yeah, and if you had 30% less short-term, shoulder season rentals, would that stop the drunk person from knocking on the wrong door? I think so.
Well, yeah. I don't know. I mean, would a total of 14 even be okay, Stephen? What do you think? I mean,
And again, like the
instead of
data
12?
that I have for the broker managed rentals, we're not indicative of the whole market. I would say that for what I do, for what Condon and Coleman does, and for what I understand NAREP's data to be, that would be fine. But we only see about half of the market. So I don't know how many homeowners that would be devastating for.
So what about 12 per year, 12 weeks per year? And instead of doing 6 or 7, 12 turnovers per year, instead of doing 6 or 7, and we do a minimum stay for July and August of 7 nights. Then if they're running it out for 2 weeks, in July, and then they use it for a week, for 2 weeks in August, that gives them more flexibility in the shoulder seat.
Yeah, I don't know that you can say at one point you're gonna set a minimum stay length and then say that you're giving people flexibility. I don't think that's-
yeah, we did try to explain the other day that the changes of occupancy does both protect neighborhoods and also gives renters flexibility. And I think it'd be good to keep it as like 6 in the high season and then however many more in the rest of the season. I think it would be easier to explain to everyone rather
It
than.
should be,
I
it
feel like
should
it's
be,
pretty easy.
it should be simple, that if you have,
The week minimum.
but if you have 12 a year, so I think we should definitely be talking about summer and shoulder separately, because the economics are gonna focus people to do into the more expensive weeks, to make their money. And then you have even less use in the.
But at 6 per week or 7, or, you're essentially still putting a 7-night minimum on July and August.
Not
Not
necessarily.
necessarily, you're just giving people the option of doing so many changeovers and the property's empty. If they wanna do short weekends, because that's what works for them, they can.
And I will say this, we're getting more requests for people who want to come for 5 and 6 days because they can't get ferry reservations. They can't come for a full week.
They may never get a ferry.
And maybe that'll never change. I don't know.
All, I just want to put a 5-minute warning.
So I think we should, I'm sorry, Charity, but I think we should pursue
Can I just make
the
one-
idea of summer
Jim.
and the rest of the time. Sorry, no.
I didn't- You're starting to get things complicated. And that's gonna be, people are gonna get, they're not gonna understand it. People are gonna say it's difficult to enforce. Make it simple, like, for example. You limit in the summer, no limit on the shoulder seasons. That is so simple.
Yeah, and I think it's.
And
We like that.
That will also drive the economy. I mean, I'm a neutral party here. My advice is simplicity.
Stephen, looking back to the work group, we were, I believe, unanimous on that, not
Yes.
limiting the shoulder.
Right.
Shoulder
Season.
Thank you.
So
It's
I
been
would
a long week.
I would suggest this. I think we should have a summer turnover limit. And I would suggest we not have a shoulder season turnover limit, with the idea that if it turns out that 2-3 years from now, we are seeing that there are big problems, we can then say, okay, you can only have, we can put it in later. But let's see, let's give people a little breathing room with the idea that if it turns out actually those are the worst ones and we gotta cut that, you know, we don't have only one shot.
I just think.
Well, there-
Grant and then Charity?
Can I just ask a question through you to John Giorgio?
Yeah.
John, if we put a
Thursday.
limit in July and August in the zoning bylaw, can we put a limit in the shoulder seasons later in the general bylaw, or do they have to be in the same?
Um, I think you could put it in the zoning bylaw. Let's deal with coming up with a set of regulations, and then I think we need to really look at where they belong in the general bylaw or the zoning bylaw.
Okay,
Fair, Charity. Then Jim.
I mean, one of the things I think we have to consider, if this is not our article, this is going to be the select board's.
That's right.
And all these are, whatever the article is, if the select board can come up with an article, all of them can be amended on the floor. And so if you said six, for July and August. And then we set something, maybe just say 4 or 8 or something like that in the shoulder season. You can be damn sure that that's going to be amended on the floor. Because people are going to think about their circumstances and try to get a different outcome.
Well,
I'm gonna go,
I'll just go quickly. I think we should avoid amendments on the floor. Because as soon as you have amendments on the floor, the meeting starts going on, and people are arguing, well, it should be 5, it should be 6.5. I mean,
Well,
I'm
simplicity.
gonna go to Dave.
And that's all I'm gonna say.
Dave?
A couple things. It will be impossible to avoid amendments on the floor. You're not gonna get 1,200 people to agree not to amend something. Two, I think that we as a group should put some serious thought into if there's pieces of this regulation that we feel need to be more fluid and changed, that possibly zoning isn't the best place for it, and maybe 123 is. Unless it is something that is so possibly damaging that people are nervous about it. But I think anything that we want to look to manipulate in the future to better serve us as a community, I would suggest they're better in 123 than 139. Thank
Thanks,
you.
Dave. I'm gonna go to Jim and then Charity, and then we'll adjourn for
I
you.
just wanted to say to Charity, thank you for reconsidering your 8 per year and maybe boosting it up. I just want to say that's the sort of thing we're all gonna try to do in the next few meetings, and that's what I hope we'll be able to do and come to something that we all can
Agreed.
accept.
Thank you, but I think these items need to be in the zoning. As opposed to a general,
So they can't be changed.
so they can't be.
they do give the zoning bylaw teeth, but they also make it harder for them to be approved.
But
And
And
I think
Charity,
zoning would work. I'm sorry, I think zoning can work if we all 3 are able to agree. I think we can get it.
And if there was,
Yeah.
if we knew there would be enforcement, maybe we could go to a bylaw, but I think these are very important elements in this whole thing.
So I just want to say.
I'm
you know,
not
like,
disagreeing.
my group is really at 9, not 6.
Oh,
But that doesn't mean we couldn't come down,
You
but
said 7.
I said we could talk about that. But
what's the meaning of talk?
But yeah, but my Jim had asked me to clarify a point, or maybe Grant said it, and we don't need to talk about it, but I just want to put it out there for people to think about. I think that what we should be doing is limiting the number of weeks that you have in a 2-tiered system. That if you have owned your property for 3 years or some period of time, you get X weeks. And if you have owned your property for less than, whatever that period of time is, say 3 years, you get less weeks. And what I think that does is create a significant economic impediment for investor focused purchases, because they are then being told, you can buy it, but you can only have 4 or 5 weeks for the first 3 years. If you want to get the, you know, whatever the higher number is, you gotta wait. And I think that, is something we should think about.
I like that.
Less
But that's,
weeks.
No violation.
that's part of everyone's homework for the weekend.
Thank you.
We got through half of them.
I would entertain a motion to adjourn.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Those opposed? Motion carries. Thank you all.
Go Celtics.
Go Celtics.
No, if we're offline, I would just.
I'll try not to.
Like to say how great this. I mean, everybody that comes in.
Yeah.